The Paul Kessler death case was not just a sentence, it was institutional betrayal. This case was not only about one defendant. It became a test of whether judges, prosecutors, and the legal system would protect the public's interest in truth. And in my opinion, they failed. This reflection is not about private grief. Grief belongs to the family. Pain belongs to those who lost someone they loved. No outsider has the right to use that pain as a performance. This reflection is about public authority, what happens when courts and prosecutors act in the name of the people, but the visible result looks less like justice and more like institutional protection of the defendant. Paul Kessler died after a political confrontation in California. The case arose in an atmosphere where ideology, group hostility, witness conduct, social media, and motive demanded serious examination. Yet the public record leaves a disturbing impression. The hate crime question appears to have been narrowed early, while the public received no complete explanation of how investigators evaluated the ideological setting, preserved digital evidence, examined witness coordination, or protected the record from being reshaped over time. That matters because delay is not neutral. Delay gives people time. Time to delete. Time to coordinate. Time to forget. Time to revise statements. And time to wait for public attention to fade. When the defendant remains free while sensitive evidence may still be unstable, the public is entitled to ask whether the system protected truth, or convenience. When judicial silence became cooperation. Then came the defense narrative. The defense attempted to transform Paul Kessler from the victim of a fatal confrontation into the aggressor. It disputed the meaning of the encounter, questioned the connection between the defendant's actions and Kessler's fatal injuries, and advanced interpretations that appeared to conflict with medical findings, the prosecution's allegations, and ultimately the defendant's own admissions. A defense lawyer may challenge evidence, question witnesses, and argue that the prosecution has not proved its case. But the right to defend an accused person should not become permission to replace documented facts with whatever narrative produces advantage. That is where the judges mattered. They did not have to become prosecutors or speak for the victim. But they did have the authority, and, in my opinion, the responsibility, to distinguish legitimate legal disagreement from factual distortion. They could have identified which facts remained disputed and which were documented. They could have explained whether the defense was offering an alternative legal interpretation or contradicting the evidentiary record. They could have corrected misleading statements, issued findings, written an opinion, or placed even a brief acknowledgement on the record. They did none of those things in any publicly visible way. There was no meaningful adjudication of the disputed narrative and no clear statement that the defense was entitled to dispute facts without the court accepting those assertions as true. The narrative was simply allowed to remain, without a visible judicial boundary around it. That silence was not neutral. The defendant continued to speak through counsel. The dead victim could not answer. The family could object, but it did not control the courtroom. Only the judge could separate advocacy from fact and argument from evidence. When that authority is not used, a disputed narrative can acquire legitimacy merely because it survives unanswered. The same pattern appeared in the repeated postponements. The defense sought more time, and the courts repeatedly allowed more time, without any publicly visible effort to confront the cumulative harm caused by more than 2 years of delay. The judges were not inactive in general. They acted when the defense requested additional time or procedural accommodation. What they did not do was impose a visible boundary when the integrity of the record, the dignity of the victim, and public confidence required one. In that context, judicial inaction was not merely passivity. It functioned as cooperation. Delay as judicial sovereignty. The old principle says that justice delayed is justice denied. California law appears to recognize urgency. It begins with short periods for a preliminary hearing and for bringing a felony case to trial. But the numbers matter only if someone is actually required to obey them. If 10 days can become months and 60 days can become years through waivers, continuances, findings of good cause, and judicial approval, then the written deadline does not control the courtroom. The courtroom controls the deadline. Perhaps each postponement can be assigned a procedural explanation. Perhaps time was waived, counsel agreed, or the judge found good cause. But a system can justify every delay separately while never answering for the cumulative result. A preliminary hearing is postponed. Another date is moved. Trial is delayed. The family waits. The public is told that the process is still working. And more than 2 years disappear. A continuance does not grant itself. A hearing does not postpone itself. A trial date does not move itself. Every delay requires judicial permission. A law that can always be displaced by discretion is not a meaningful limit on judicial power. It becomes a powerless suggestion. When the law announces 10 days or 60 days but the court can repeatedly authorize something else without a meaningful consequence, those numbers become ceremonial. They announce urgency but do not enforce it. They appear to restrain power but do not reliably restrain the judge. When the same official controls the calendar, interprets the exception, determines good cause, and decides whether any remedy follows, the courtroom begins to operate less as government by fixed law and more as government by judicial permission. The law supplied the numbers. The judges decided whether the numbers mattered. In this case, they visibly did not. The unanswered hate crime question. The district attorney declined to charge a hate crime. Hateful speech alone is not automatically a crime. But once violence occurs, words, social media, group conduct, target selection, and ideological context may become evidence of motive. The question is whether the act was committed, at least in part, because of who Paul Kessler was or what group he was perceived to represent. The public explanation appeared to focus heavily on the absence of proof that the defendant personally uttered an anti-Semitic slur during the physical act. But motive is rarely announced in perfect legal language at the moment of violence. It is usually reconstructed from circumstances before, during, and after the event. California law does not require hatred to be the only motive. It asks whether the offense was committed, in whole or in part, because of an actual or perceived protected characteristic, including religion. The important question, therefore, is not whether prosecutors could prove hate immediately. It is whether they investigated motive aggressively before posts could disappear, memories could change, witnesses could coordinate, and a politically charged confrontation could be reduced to a generic street dispute. The public was told that the threshold was not met. But the explanation seemed to reduce motive to one missing sentence, as though the defendant had to say the quiet part aloud at the precise moment of impact. If that was the practical standard, then hate was narrowed until almost nothing could fit inside it. Selective certainty. Another disturbing feature of the public record is the way official certainty seemed to move. At one point, officials described video, images, reconstruction, search warrants, medical findings, and enough evidence to bring serious charges. At other points, the public was told that witnesses conflicted and that important details about what happened before Kessler fell remained uncertain. If the evidence was clear, the public was entitled to a clear prosecution. If it was uncertain, officials should not have spoken as though the essential picture had been settled. What they could not credibly do was use certainty when filing charges, uncertainty when explaining the absence of hate crime consequences, certainty when calming public concern, and uncertainty when defending the final result. A justice system cannot use clarity as a shield and uncertainty as an escape hatch. That is not transparency. It is selective certainty. The prosecutor represents the people, not the defendant, the court, convenience, or institutional peace. The public deserved a serious and visible explanation of the hate crime inquiry, what digital evidence was preserved, which witnesses and ideological statements were examined, whether group communications were reviewed, and how officials reached their conclusion. The public record does not answer those questions. Silence does not prove that nothing was done, but in a case of this importance, unexplained silence does not create confidence. It creates suspicion. The final judicial act. Then came the final act. The defendant pleaded guilty to involuntary manslaughter and battery. The admissions included serious bodily injury, weapon use, and the vulnerability of the victim. Those were not decorative words. They were admissions that should have carried substantial weight. Yet the court itself reportedly opened the door to a jail and probation outcome. The judge was not merely accepting a disposition forced by the parties. The court became the source of the soft landing. The result was a death answered with a limited period of county confinement and felony probation. The conviction remained on paper, but the punishment did not appear to express the seriousness of the admitted conduct, the loss of life, deterrence, or public confidence. The court did not erase the conviction. It reduced the practical meaning of the conviction. When victim rights become ceremony. Victim rights are described in solemn language. Courts speak of dignity. Prosecutors speak of voice. The system says that victims and the public matter. But participation is not the same as influence. The family could speak, yet it could not control the delay, compel a full explanation of the hate crime decision, restrain the defense narrative, or prevent the court-indicated sentence. That is why the final outcome felt larger than one sentence. It conveyed that the victim's side could be heard without being allowed to alter the institutional direction of the case. The system seemed to say, "We heard you. We processed you. We let you speak. And now we will do what we had already decided to do." That is not meaningful participation. It is managed disrespect. Closing. The Kessler case is not only about the death of one man. It is about what public institutions do afterward. Do they preserve evidence, investigate motive honestly, distinguish fact from advocacy, impose meaningful limits on delay, and punish admitted crimes with seriousness? Or do they postpone, soften, minimize, and move on? In this case, the visible record points to a painful conclusion: the defendant did not defeat public justice alone. He was assisted by the system's failures. When judges and prosecutors fail to protect public trust, the wound is not only personal. It becomes civic. Because the courthouse does not belong to the judge. It does not belong to the lawyers. It does not belong to the defendant. It belongs to the people. And in the Paul Kessler case, the people were left with a sentence, a silence, and a question. Who, inside the justice system, was still defending justice? The judges did not defend justice. Through repeated delay, unexplained silence, and a sentence favorable to the defendant, they helped undermine it.